In the pre-dawn darkness of May 2nd, 2025, two cell phones pinged off the same tower in rural Nova Scotia. The tower covered a remote stretch of woodland where few people venture, where the trees grow thick and the paths are unmarked, where someone looking to hide something could disappear into the shadows and emerge hours later, leaving almost no trace. But almost no trace isn't the same as no trace at all. 7 months later, investigators have pieced together what happened in those woods. They know who was there, they know what they were doing, and they know why. An arrest is coming, and when it happens, everything we thought we knew about the disappearance of Lily and Jack Sullivan will be turned upside down. This is the Untold Cold Case. I'm your host, and what you're about to hear will change how you see this entire investigation. Before we begin, I need you to do something for me. Hit that subscribe button right now. This case is developing rapidly, and new information is emerging every single day. If you're not subscribed with notifications turned on, you're going to miss critical updates. So do it now. Click subscribe, turn on that notification bell, and then drop a comment below telling me where you're watching from and what time it is in your part of the world. I want to know who's part of this community, who's standing with me demanding answers, demanding justice, demanding accountability for what happened to two innocent children who should still be playing in their backyard, laughing with their friends, living the childhood they deserved. And hit that like button too. I know it seems like a small thing, but it genuinely helps. It pushes this video to more people. It gets this information in front of more eyes. And the more people who know about this case, the more pressure there is for justice. All right, let's talk about what just happened in the Lily and Jack Sullivan case. On May 2nd, 2025, in the small, tight-knit community of Picto County, Nova Scotia, two children vanished without a trace. 6-year-old Lily Sullivan, 4-year-old Jack Sullivan, brother and sister, gone from their family property under circumstances that investigators knew immediately were deeply suspicious. For 7 months, the Royal Canadian Mounted Police, the RCMP, have been working this case around the clock. They've conducted extensive ground searches involving hundreds of volunteers. They've interviewed dozens of witnesses. They've analyzed thousands of pieces of evidence. They've followed every lead, chased down every tip, pursued every possible angle. And now, sources close to the investigation have confirmed to multiple media outlets that an arrest is imminent. Not just any arrest, an arrest that changes the entire trajectory of this case. The person about to be taken into custody isn't someone whose face has been plastered across news broadcasts for the past 7 months. It's not someone investigators publicly named as a person of interest in their early press conferences. It's not someone whose social media profiles have been dissected by amateur sleuths online. It's Darren Gettys, a 34-year-old man who lives approximately 15 kilometers from the Sullivan family property. A man whose name, until this week, had barely been mentioned in connection with this case, a man who seemed completely peripheral to everything that happened. But investigators have been watching him. They've been building a case against him quietly, methodically, patiently. And now they're ready to move. To understand why Darren Gettys' arrest is so significant, we need to go back to the beginning, back to May 2nd, 2025, back to the day this entire nightmare began. The Sullivan family lived on a rural property in Picto County, Nova Scotia. It's the kind of place where neighbors know each other by name, where kids ride bikes on quiet roads, where the pace of life is slower than in the cities, where people still leave their doors unlocked and trust their community. Lily Sullivan was 6 years old. By all accounts, she was bright, curious, full of energy. She loved drawing pictures and playing outside. She'd just finished kindergarten and was excited about starting first grade in the fall. Jack Sullivan was 4 years old. He was Lily's little brother, her shadow, her constant companion. Wherever Lily went, Jack wanted to follow. They were close in the way siblings sometimes are when they're young and the world still feels safe and full of possibility. On the evening of May 1st, 2025, everything seemed normal. The children were home with their mother, Malaya Brooks Murray, and her partner, Daniel Martell. It was a quiet Thursday night, nothing out of the ordinary, nothing that would suggest that within hours everything would change. But something did happen that night, something that led to both children disappearing by the morning of May 2nd. When investigators arrived at the property on May 2nd, responding to a report that the children were missing, they immediately noticed inconsistencies in the story they were being told. Details that didn't add up, explanations that didn't make sense, behavior that seemed off. Experienced investigators develop an instinct for these things. They can sense when something isn't right, when a story has holes, when people are being evasive or deliberately deceptive. And from the very first day, investigators suspected that whatever happened to Lily and Jack, it wasn't a simple case of two children wandering off and getting lost in the woods. The evidence supported that suspicion. There was no sign of forced entry at the property, no indication that someone from outside the household had come in and taken the children. No witnesses who saw a stranger in the area, no vehicle that didn't belong speeding away from the scene. The dogs that searched the property, highly trained cadaver dogs with years of experience, indicated in specific areas. They alerted their handlers to the presence of something significant, something that suggested this wasn't just a missing persons case. And then there were the cell phone records. This is where the investigation started to build momentum, where investigators began to piece together a timeline that would eventually lead them to Darren Gettys. Cell phone records obtained through legal search warrants showed unusual activity on the night of May 1st and the early morning hours of May 2nd. Calls made at odd times, text messages sent and then deleted, and location data that placed certain individuals in certain places at times that contradicted the statements they'd given to police. One call in particular caught investigators' attention. At 11:32 p.m. on the night of May 1st, Daniel Martell placed a call to Darren Gettys, 11:32 at night. Think about that for a moment. That's late. That's after most people have settled in for the evening. That's not the time you casually call someone, unless something is wrong, unless you need help, unless something urgent has happened that can't wait until morning. The call lasted 7 minutes. 7 minutes is a long time for a phone conversation late at night. That's not a quick check-in. That's not a brief exchange. That's a substantive conversation. That's explaining something, asking for something, coordinating something. The investigators obtained the phone records through proper legal channels, presenting their evidence to a judge and receiving authorization for the warrants. Everything done by the book, everything admissible in court, and what those phone records revealed was damning. The call from Daniel to Gettys at 11:32 p.m. on May 1st was followed by a series of text messages. Short exchanges, planning something, coordinating logistics. Then at 11:47 p.m., Daniel was captured on security camera footage at a local gas station. He was alone. He purchased several items. The footage shows him appearing agitated, rushed, looking around nervously. This gas station visit became a critical piece of the timeline because it shows Daniel's movements. It pins him to a specific location at a specific time. And it raises the question, why make a gas station run at nearly midnight? What did he need so urgently? Investigators believe the answer to that question is directly connected to what happened to Lily and Jack. After the gas station visit, Daniel returned to the property. The cell tower data shows his phone back in the area of the Sullivan residence by approximately 12:15 a.m. And then, in the hours that followed, something happened that would eventually lead investigators straight to Darren Gettys. Between the hours of 4 a.m. and 6 a.m. on May 2nd, both Daniel Martell's phone and Darren Gettys' phone were pinging off the same cell tower. This is crucial. This is the kind of evidence that builds cases because cell tower data doesn't lie. It's objective. It's scientific. See, it places people in specific geographic areas at specific times. The tower in question covers a stretch of densely forested land adjacent to the Sullivan property. It's not an area where people typically go. There are no hiking trails there, no popular fishing spots, no reason for someone to be wandering around in those woods at 4 or 5 in the morning, unless they're trying to hide something. The cell tower data shows that both phones remained in that area for approximately 2 hours, from around 4 a.m. until just after 6 a.m., 2 hours in the woods in the pre-dawn darkness. What were they doing there? Investigators have a theory, and it's supported by additional evidence that we'll get to in a moment. But first, let's talk about who Darren Gettys is and how he's connected to Daniel Martel. Darren Gettys is a 34-year-old man who has lived in Picto County for most of his life. He works in construction, doing manual labor jobs that are common in the area. Renovations, landscaping, general contracting work. The kind of jobs that are steady when the economy is good, but can dry up quickly when times are tough. Gettys met Daniel Martel approximately 6 years ago through work. They were both doing construction jobs in the area, sometimes working on the same crews, sometimes just crossing paths at supply stores or job sites. They weren't best friends. They didn't spend every weekend together, but they were friendly. They'd grab beers together after work sometimes. They'd help each other out with odd jobs when one of them needed an extra pair of hands. According to people who know both men, Daniel considered Gettys someone reliable, someone trustworthy, someone who wouldn't ask too many questions, someone who valued loyalty and would help a friend out when that friend was in trouble. That relationship, that sense of loyalty and trust, may be what led Daniel to call Gettys at 11:32 p.m. on May 1st, because when you're in a situation where you need help, when something has happened that you can't handle alone, you call someone you trust, someone who won't panic, someone who won't go to the authorities, someone who will do what needs to be done and keep quiet about it. And based on the evidence, that's exactly what Darren Gettys did. Let's walk through the evidence investigators have compiled over the past 7 months, because this isn't speculation, this isn't guesswork, this is hard evidence. The kind of evidence that holds up in court. First, as we've already discussed, there are the phone records and cell tower data. The 11:32 p.m. call from Daniel to Gettys on May 1st. The text messages that followed. The cell tower data showing both phones in that wooded area between 4 and 6 a.m. on May 2nd. That's evidence item number 1, irrefutable digital evidence that places both men in communication and then in the same location at a critical time. Second, there's physical evidence recovered from Gettys' vehicle. In the weeks following the children's disappearance, investigators obtained search warrants for multiple vehicles, including Gettys' truck. These searches were conducted by forensic specialists who know exactly what to look for, who understand that even when someone tries to clean a vehicle, traces of evidence remain. The specific details of what was found in Gettys' truck have not been made public. Investigators are protecting that information to preserve the integrity of their case, but sources close to the investigation have confirmed that physical evidence was recovered that links Gettys directly to the scene. This could be soil samples matching the composition of soil in that specific wooded area. It could be fiber evidence. It could be DNA evidence. Whatever it is, it's significant enough that prosecutors feel confident moving forward with charges. That's evidence item number 2, physical evidence that puts Gettys at the scene. Third, there are the deleted text messages. When investigators initially obtained Gettys' phone, they found that numerous text messages between him and Daniel Martel from the night of May 1st and morning of May 2nd had been deleted. Now, deleting messages isn't unusual in and of itself. People delete messages all the time for all sorts of innocent reasons, but in the context of a criminal investigation, the deliberate deletion of messages from a specific time frame is significant. It shows consciousness of guilt. It shows an awareness that those messages contained information that could be incriminating. It shows an attempt to conceal evidence. Fortunately for investigators, deleted doesn't mean gone forever. Phone forensics experts, specialists who do this work day in and day out, were able to recover many of those deleted messages. And what those messages show is coordination between Daniel and Gettys, planning, logistics, times and locations. The kind of detailed communication that occurs when two people are working together on something they don't want anyone else to know about. One recovered message sent from Daniel to Gettys at approximately 12:45 a.m. on May 2nd simply reads, "Need you at the spot, 4 a.m., don't be late." the spot, 4 a.m. Those aren't the words of someone planning an innocent early morning activity. Another recovered message, sent from Gettys to Daniel at around 5:30 a.m., reads, "Done, heading back, no one saw." Done, no one saw. Again, these aren't messages about anything innocent. That's evidence item number 3. Digital communications showing guilty knowledge and coordination. Fourth, there's the eyewitness testimony. This is perhaps the most damaging piece of evidence against Gettys. See, because while phone records and physical evidence can be powerful, there's something uniquely compelling about a witness who saw something with their own eyes. On the morning of May 2nd, at approximately 5:45 a.m., a local resident was out walking their dog on a rural road that borders the wooded area where the cell tower data placed Daniel and Gettys. This resident, whose identity is being protected by investigators, saw 2 men emerge from the tree line and walk toward a truck parked on the shoulder of the road. Both men were carrying shovels. The witness didn't think much of it at the time. This is a rural area. People do outdoor work. Seeing someone with tools early in the morning isn't inherently suspicious, but the witness did note the time, approximately 5:45 a.m., and the location. And when investigators started canvassing the area in the days following the children's disappearance, this witness came forward with that information. Initially, the witness couldn't identify the men they'd seen. It was early morning, still somewhat dark, and they'd only seen them briefly from a distance. But investigators showed the witness photographs. Multiple photographs of different individuals in a properly conducted photo lineup. No suggestion of who they should pick. No pressure to identify anyone in particular. And the witness identified both Daniel Martel and Darren Gettys as the 2 men they'd seen emerging from the woods carrying shovels on the morning of May 2nd at approximately 5:45 a.m. That's evidence item number 4. Item, and a direct eyewitness testimony placing both men at the scene with tools commonly used for digging. And fifth, there's Gettys' own behavior in the days and weeks following May 2nd. Investigators conducted surveillance on Gettys for weeks. They monitored his movements. They noted his behavior patterns. They looked for any indication that he was aware he was being watched or that he was taking steps to conceal his involvement. And what they observed was telling. Gettys avoided Daniel Martel completely. 2 men who had been friendly for 6 years, who'd occasionally grab food together, who'd help each other with odd jobs, suddenly had 0 contact. No phone calls, no text messages, no running into each other at local businesses. That complete cessation of contact is significant. Because innocent people who are friends don't suddenly cut off all communication unless there's a reason, unless they've been told by lawyers not to have contact, unless they're trying to avoid creating any additional evidence that could link them together. Investigators also noted that Gettys appeared anxious and agitated during this period. He was jumpy. He was looking over his shoulder. He was checking his phone constantly. All behaviors consistent with someone who knows they've done something wrong and is waiting for law enforcement to catch up with them. That's evidence, item number 5. Behavioral evidence showing consciousness of guilt. When you put all 5 pieces together, the phone records, the physical evidence, the deleted text messages, the eyewitness testimony, and the behavioral evidence, you have a compelling case. This isn't circumstantial evidence that could be explained away by coincidence. This is multiple independent streams of evidence all pointing to the same conclusion. Darren Gettys was involved. He helped Daniel Martel on the morning of May 2nd. He was in those woods. He knows what happened, and he's been trying to hide it for 7 months. I want to pause here for just a moment to talk to those of you who are watching this video but haven't yet subscribed to the channel. This case is ongoing. It's developing. New information is coming out regularly, and I'm going to be here covering every single development as it happens. But if you're not subscribed, you're going to miss those updates. You're going to miss the breaking news. You're going to miss the analysis and the context that helps make sense of what's happening. So do yourself a favor right now. Click that subscribe button. It's free. It takes 2 seconds and it ensures you don't miss anything. Also, hit that like button I know I've already asked once, but it genuinely makes a difference. YouTube's algorithm looks at engagement. The more likes a video gets, the more people YouTube shows it to, and this is information that people need to see. Finally, drop a comment below. Tell me what you think about this evidence. Do you think it's enough to convict Gettys? Do you think he's going to take a deal and cooperate with prosecutors? I read every comment and I want to know what you're thinking. All right, let's get back to the case. So we know the evidence against Darren Gettys is substantial. We know investigators have been building this case for months, and now, according to multiple sources close to the investigation, an arrest warrant has been prepared. That warrant has been reviewed by prosecutors. It's been presented to a judge, and it's been signed. What that means is that at any moment, possibly within the next 24 to 48 hours, RCMP officers are going to execute that warrant. They're going to take Darren Gettys into custody. Let me walk you through what that process is going to look like. When officers execute the arrest warrant, they'll approach Gettys at his residence or wherever they locate him. They'll identify themselves as law enforcement. They'll inform him that he's under arrest and read him his rights. In Canada, the rights that must be read to someone upon arrest are similar to what Americans know as Miranda rights. The right to remain silent, the right to speak with an attorney, the warning that anything said can be used as evidence. Once Gettys is in custody, he'll be transported to an RCMP detention facility. He'll be processed, which includes being photographed, fingerprinted, and having his personal belongings catalogued. Then, within 24 to 48 hours of the arrest, he'll have what's called an arraignment hearing. This is his first appearance before a judge. At the arraignment, several things happen. First, the charges against Gettys will be formally read aloud in court. The prosecutor will state exactly what criminal charges the government is bringing and what statutes those charges are based on. Second, Gettys will have the opportunity to enter a plea. In nearly all cases at this stage, defendants plead not guilty. See, even if they ultimately plan to take a plea deal or know the evidence against them is overwhelming, it's standard practice to enter a not guilty plea at arraignment. It preserves all legal options and doesn't foreclose any defense strategies. Third, the judge will make a decision about bail. This is a critical moment in the process. The bail decision determines whether Gettys will be released pending trial or whether he'll remain in custody. In making the bail decision, the judge considers several factors. Is the defendant a flight risk? Does he have ties to the community, family obligations, employment, reasons to stay? Or is there a risk he'll flee to avoid prosecution? Is the defendant a danger to the community? Is there a risk he'll commit additional crimes if released? Is there a risk the defendant will interfere with the investigation? Will he contact witnesses, destroy evidence, or otherwise obstruct justice? In Gettys' case, prosecutors are likely to argue strongly that he should be denied bail and held in custody pending trial. They'll point to the seriousness of the charges. They'll argue that someone facing the possibility of decades in prison has a powerful incentive to flee. They'll note that Gettys has already demonstrated a willingness to conceal evidence and obstruct the investigation, as evidenced by the deleted text messages and his behavior over the past 7 months. They'll also argue that releasing Gettys could compromise the ongoing investigation, that he might contact other witnesses or persons of interest, that he might attempt to further destroy or conceal evidence. Gettys' defense attorney will argue the opposite. They'll point out that Gettys has lived in the community his entire life, that he has family ties here, that he's not a flight risk because he has nowhere to go and no resources to disappear. They'll argue that he's not a danger to the community, that whatever he's alleged to have done was a one-time event in unique circumstances, not indicative of ongoing violent behavior. They'll propose conditions for release: electronic monitoring, regular check-ins with law enforcement, surrender of his passport, restrictions on his movement. The judge will weigh these arguments and make a decision. Given the nature of this case, given the seriousness of what happened to Lily and Jack, given the public attention and the community impact, there's a real possibility the judge will deny bail and order Gettys held in custody pending trial. That would mean Gettys spends the next several months, possibly longer, in jail while waiting for his case to proceed through the court system. Now let's talk about the specific charges Gettys is likely facing. Based on the evidence we've discussed and the typical charges in cases of this nature, prosecutors are likely to charge Gettys with multiple criminal offences. The first and most serious charge is likely to be accessory after the fact. Under Canadian criminal law, someone is an accessory after the fact if they, knowing that a person has committed an offence, receive, comfort or assist that person for the purpose of enabling them to escape arrest or prosecution. If prosecutors can prove that Gettys knew something had happened to Lily and Jack and that he helped Daniel Martel conceal evidence or avoid detection by law enforcement, that constitutes being an accessory after the fact. The maximum penalty for being an accessory after the fact to a serious indictable offence in Canada is 14 years imprisonment. 14 years? That's not a minor charge. That's serious prison time. The second charge Gettys is likely facing is obstruction of justice. Obstruction of justice occurs when someone willfully attempts to obstruct, pervert, or defeat the course of justice. This can include destroying evidence, providing false information to investigators, or helping someone else avoid arrest. The deleted text messages alone could support an obstruction charge. But when you combine that with the alleged activities in the woods on the morning of May 2nd, with the eyewitness testimony of two men with shovels emerging from an area investigators believe evidence was concealed, the obstruction charge becomes even stronger. The maximum penalty for obstruction of justice in Canada is up to 10 years imprisonment. The third charge is likely tampering with evidence. Evidence tampering, also known as interfering with evidence, occurs when someone destroys, conceals or alters physical evidence with the intent to impair its availability or usefulness in an investigation or legal proceeding. If Gettys helped hide evidence in those woods, if he participated in activities designed to make it harder for investigators to find what they were looking for, that's evidence tampering. And this charge carries penalties similar to obstruction of justice, up to 10 years imprisonment depending on the severity. There could be additional charges as well, depending on exactly what prosecutors can prove about what Gettys knew and when he knew it. If they can demonstrate that Gettys had specific knowledge of what happened to the children before he agreed to help Daniel, the charges could be enhanced or additional charges could be added. If they can show that Gettys was involved in planning rather than just execution, that could affect the charges and potential sentences. But at minimum, based on the evidence we know about, Gettys is looking at charges of accessory, after the fact, obstruction of justice, and tampering with evidence. Even if the sentences for these charges run concurrently, it's meaning he serves them at the same time rather than consecutively one after another, Gettys is potentially facing 10 to 14 years in prison if convicted. That's a significant portion of a person's life. For a 34-year-old man, that means potentially being behind bars until his mid to late 40s. And that brings us to what could be the most important question in this entire case. Will Darren Gettys cooperate with prosecutors? In the criminal justice system, cooperation deals are common. They're a tool that prosecutors use to build cases against more culpable defendants by offering reduced sentences to less culpable ones. The logic is straightforward. If you can get someone who played a supporting role to testify against someone who played a primary role, you increase your chances of securing a conviction against the person who bears the most responsibility. In this case, Darren Gettys was not, based on everything we know, present when the incident that led to the children's disappearance occurred. He wasn't in the Sullivan household on the evening of May 1st. He didn't make the decisions or take the actions that resulted in Lily and Jack vanishing. What he allegedly did was help after the fact. He allegedly helped Daniel Martel conceal evidence. He allegedly participated in a cover-up. That's serious, that's criminal. But it's different from being the person who actually harmed the children. And that distinction matters when prosecutors are considering who to offer deals to. Here's how these negotiations typically work. After Gettys is arrested and arraigned, his defense attorney will request a meeting with the prosecuting attorneys. These meetings often happen within days of the arraignment. At that meeting, prosecutors will lay out the evidence they have against Gettys. They'll show the phone records, the cell tower data, the physical evidence, the recovered text messages, the eyewitness testimony. They'll make it clear that they have a strong case. Then they'll explain what Gettys is facing if he goes to trial and is convicted 10 to 14 years in prison a substantial portion of his life behind bars, a criminal record that will follow him forever. And then they'll make an offer. The offer will be conditional on full cooperation, complete truthfulness, total transparency. Gettys will have to provide a detailed statement about everything he knows when Daniel called him. What Daniel said, what Daniel asked him to do, where they went, what they did in those woods, everything. He'll have to show investigators where evidence is located. If there are items that were buried or hidden, he'll have to take investigators to the exact spots. He'll have to agree to testify at Daniel Martel's trial. He'll have to get on the witness stand under oath and tell a jury exactly what happened. He'll be subject to cross-examination by Daniel's defense attorneys, who will try to undermine his credibility and poke holes in his story. But if he does all of that, if he cooperates fully and truthfully, prosecutors will offer something in return. They'll reduce the charges. Instead of being charged with accessory after the fact to the most serious possible offense, they might reduce it to a lesser included offense with a lower maximum sentence. They'll recommend a specific sentence to the judge that's significantly less than the maximum. Instead of 10 to 14 years, they might recommend 5 to 7 years, or even less, depending on the level of cooperation and the value of the information provided. They'll agree to make a statement at sentencing about Gettys' cooperation, telling the judge that he helped the investigation, that he showed remorse, that he took responsibility for his actions. For someone in Gettys' position, facing the prospect of over a decade in prison, that kind of offer can be incredibly compelling. And it's not just about the reduced sentence. It's about the difference between being seen as someone who helped perpetrate a terrible crime versus someone who made a terrible mistake, but ultimately did the right thing by helping bring the truth to light. That distinction might not matter much in the courtroom, but it can matter in other ways. How he's treated in prison, how the community perceives him after he's served his time, how he sees himself. Now you might be wondering, why would prosecutors need Gettys' cooperation? They already have all this evidence against him. They have the phone records, the physical evidence, the eyewitness testimony. Can't they just use all that to convict Daniel Martel as well? The answer is, it's not quite that simple. Much of the evidence against Gettys places him in certain locations at certain times and shows coordination between him and Daniel, but it doesn't necessarily prove what Daniel did or what happened to the children. The phone records show Daniel called Gettys and that they communicated, but they don't show what was said in those communications beyond the few text messages that were recovered. The cell tower data shows both men were in the wooded area, but it doesn't show what they were doing there or what, if anything, they were concealing. The eyewitness saw two men with shovels, but seeing someone with a shovel isn't proof of a specific crime. To build the strongest possible case against Daniel Martel, prosecutors need someone who can testify from direct personal knowledge about what happened, someone who was there, not someone who can tell a jury, "This is what Daniel told me, this is what we did, this is where we went, this is what we buried." That kind of testimony from someone who has already pleaded guilty and has nothing to gain by lying can be devastatingly effective at trial. Defense attorneys will try to attack the credibility of a cooperating witness. They'll point out that he's getting a reduced sentence in exchange for his testimony. They'll suggest he's making things up or exaggerating to please the prosecutors. But prosecutors can counter that by pointing out that the witness's testimony is corroborated by all the physical evidence. The phone records match what he says about when calls were made. The cell tower data matches what he says about where they went. The physical evidence matches what he says about what they did. What is when a cooperating witness's testimony aligns with independent physical evidence, it becomes very difficult for a jury to dismiss it as fabrication. And that's why Gettys' potential cooperation is so valuable. If he agrees to cooperate, if he provides that detailed testimony about exactly what happened, it could be the key piece of evidence that ensures Daniel Martel is convicted. But will Gettys actually take a deal? That's the question everyone involved in this case is asking right now. There are reasons he might. The evidence against him is strong. His attorney, if competent, will advise him that going to trial is a significant risk that a jury could easily convict based on the evidence prosecutors have, that he could end up serving the maximum sentence. The potential for a reduced sentence is meaningful. The difference between 14 years and 7 years, or even 5 years, is enormous. That's years of freedom, years he could spend rebuilding his life instead of sitting in a cell. And there may be a part of Gettys that wants to come clean, that's tired of carrying the weight of what he knows, that wants to do the right thing, even if it's years too late. But there are also reasons he might not cooperate. Cooperating means admitting his involvement. It means publicly acknowledging that he helped cover up what happened to 2 children. It means facing the judgment of his community, his family, everyone who knows him. Cooperating means testifying against Daniel Martel, someone he considered a friend. In some circles, that's seen as the ultimate betrayal. There could be social consequences, even threats. And there's always the possibility, however slim, that if Gettys goes to trial, he might be acquitted. Maybe his attorney can successfully challenge some of the evidence. Maybe they can create reasonable doubt. Maybe a jury will be sympathetic. It's a gamble, but some defendants are willing to take that gamble rather than accept the certainty of a conviction that comes with a plea deal. Over the next few weeks, Gettys and his attorney will be weighing all of these factors. They'll be reviewing the evidence. They'll be discussing the strength of the prosecution's case. They'll be talking about what kind of offer prosecutors are willing to make. And then Gettys will have to make a decision that will determine not just his own future, but potentially the outcome of the entire case against Daniel Martel. While the focus right now is on Darren Gettys and his imminent arrest, it's important to remember that this is part of a much larger investigation into what happened to Lily and Jack Sullivan. Investigators have been working this case from multiple angles for 7 months. They've pursued hundreds of leads. They've conducted countless interviews. They've analyzed vast amounts of evidence. And Gettys isn't the only person they've been looking at. From the very beginning, investigators identified Daniel Martel and Malaya Brooks Murray as persons of interest. The children's mother and her partner. The 2 adults who were with the children when they disappeared. The evidence against both of them has been accumulating for months. There are the inconsistencies in their statements to police, the shifting stories about what happened on the evening of May 1st, the details that changed each time they were interviewed. There's their behavior in the days following the disappearance, the lack of emotion that struck investigators as unusual, the absence of the kind of desperate searching and pleading you'd expect from parents whose children were missing. There's the physical evidence from the property, the areas where the cadaver dogs alerted, the forensic analysis of items recovered from the house. And now, with the case against Gettys coming together, investigators have additional leverage. They have evidence of Daniel's involvement in concealing evidence. They have proof that he called in help in the middle of the night. They have a potential cooperating witness who can testify about what Daniel told him and what they did together. All of this builds toward what many observers believe is inevitable: charges against Daniel Martel and quite possibly against Malaya Brooks Murray as well. Those charges, when they come, are likely to be far more serious than the charges Gettys is facing, depending on what investigators can prove about what happened on the evening of May 1st. Daniel and Malaya could face charges ranging from manslaughter to second-degree murder to even first-degree murder if prosecutors can prove premeditation. The exact charges will depend on the evidence, on what can be proven beyond a reasonable doubt, on what a prosecutor believes they can convince a jury of. But make no mistake, Daniel Martel and Malaya Brooks Murray are not just persons of interest. They are targets of this investigation, and investigators are building cases against them just as methodically as they built the case against Gettys. The arrest of Gettys is significant not just for what it means for him, but for what it signals about the overall investigation. It shows that investigators are confident in their evidence, confident enough to start making arrests, confident enough to move this case from the investigation phase to the prosecution phase. It shows that they've been working quietly and patiently behind the scenes, not rushing, not cutting corners, building cases that will hold up in court. and it shows that everyone who played a role in what happened to Lily and Jack is going to be held accountable. That's the message this arrest sends. And no matter how peripheral your involvement seemed, no matter how much time has passed, no matter how well you thought you covered your tracks, if you were involved, investigators know, and they're coming for the Sullivan family, for Lily and Jack's extended family, who have been living with unimaginable pain for 7 months. This arrest represents progress. It doesn't bring the children back. Nothing can do that. But it shows that the system is working, that investigators haven't given up, that justice is possible. And if Gettys cooperates, if he provides the information that could finally answer the question of what happened and where Lily and Jack are, it could provide a measure of closure. The family could finally know the truth. They could finally lay the children to rest properly. They could finally begin the long, painful process of healing. That's what's at stake here, not just criminal charges and prison sentences, but the possibility of answers, of truth, of some small measure of peace for a family that's been torn apart. Let's talk for a moment about the community impact of this case. Picto County is a small community, the kind of place where major crimes are rare, where people know their neighbors, where parents let their kids play outside without constant supervision because the community feels safe. The disappearance of Lily and Jack shattered that sense of safety. For 7 months, parents in the community have been more vigilant, more protective, more fearful, because if something like this can happen, if 2 children can vanish from their own property, then nowhere is truly safe. The arrest of Darren Gettys, a local resident, someone who lived in the community, who worked alongside people they know, who seemed like an ordinary person, reinforces that fear. It's a reminder that danger doesn't always come from strangers, that sometimes the people who cause the most harm are people we think we know. But it's also a reminder that the justice system works, that law enforcement takes these crimes seriously, that there are consequences for actions. The community has rallied around the Sullivan family in remarkable ways over these 7 months. Volunteers organized search parties, combing through the woods day after day, looking for any sign of the children. Local businesses donated supplies and resources to support the search efforts. And counselors and clergy provided emotional support to the family and to other community members struggling with the trauma of what happened. That solidarity, that collective determination to find answers and support each other is what communities do in the face of tragedy. And now, as arrests begin to happen, as the case moves toward prosecution and hopefully toward resolution, the community will continue to play a role. Community members may be called as witnesses at trial. They'll be there in the courtroom, showing support for the family, demonstrating that Lily and Jack mattered, that they were loved, that they won't be forgotten. The media attention on this case has been significant from the beginning. Local news outlets have covered every development. National media has picked up the story. True crime podcasts and YouTube channels, like this one, have analyzed the evidence and followed the investigation. That attention serves a purpose. It keeps pressure on law enforcement to pursue justice. It keeps the case in the public consciousness. It ensures that Lily and Jack's disappearance doesn't become just another unsolved case that fades from memory. But media attention also has drawbacks. It can make it harder to seat an impartial jury. It can create pressure to make arrests before investigators are fully ready. It can invade the privacy of everyone involved. Finding that balance between public interest and protecting the integrity of the investigation and the rights of the accused is always challenging in high-profile cases. As this case moves forward, as Gettys is arrested and arraigned, as he decides whether to cooperate, as additional arrests potentially follow, the media coverage will intensify. And that's where channels like this one play a role, providing accurate information, putting developments in context, helping people understand what's happening and why it matters. That's what I'm committed to doing. Covering this case thoroughly, responsibly, and with respect for everyone involved, especially for Lily and Jack and their family. So where does this case go from here? In the immediate future, within the next 24 to 48 hours, we're expecting the arrest of Darren Gettys. That arrest will be major news. It will be covered extensively by local and national media, and it will mark a significant turning point in this investigation. Following the arrest, Gettys will have his arraignment hearing. That hearing will likely be open to the public and media, though cameras may not be allowed in the courtroom depending on local rules. At the arraignment, we'll learn the exact charges that prosecutors are filing against Gettys. We'll hear arguments about bail. We'll get our first look at how Gettys and his attorney plan to approach this case. Then, in the days and weeks following arraignment, negotiations will begin. Prosecutors will make their offer. Gettys' attorney will convey that offer and advise on whether to accept it. And Gettys will decide whether to cooperate or go to trial. If Gettys decides to cooperate, he'll provide a detailed statement to investigators. He'll likely meet with them multiple times, going over every detail of what happened. Those sessions will be recorded and documented carefully because anything Gettys says will potentially be used at trial. Or he'll also take investigators to locations where evidence may be concealed. This could finally provide the answers about where Lily and Jack are. It could allow their family to recover their remains and lay them to rest. If Gettys takes a deal, he'll plead guilty to reduced charges at a hearing scheduled for that purpose. At that hearing, the prosecutor will read a statement of facts that Gettys will have to affirm are true. This creates a record of what happened that can be used at other trials. Then, at some later date, Gettys will have a sentencing hearing where the judge will determine his actual punishment. Prosecutors will speak at that hearing about his cooperation. His attorney will present mitigating factors, and the judge will impose a sentence. If Gettys decides not to cooperate, his case will proceed to trial. That trial probably wouldn't happen for at least a year, possibly longer. The justice system moves slowly, and both sides need time to prepare. At trial, prosecutors will present all their evidence: the phone records, the cell tower data, the physical evidence, the deleted text messages, the eyewitness testimony. Gettys' attorney will try to challenge that evidence, create reasonable doubt, and convince a jury to acquit. It's impossible to predict with certainty how a trial would turn out, but based on the evidence we know about, prosecutors would have a strong case. Separate from what happens with Gettys, we're also expecting additional arrests in this case, most likely Daniel Martell and potentially Malaya Brooks-Murray. Those arrests could come soon after Gettys' arrest, and especially if Gettys cooperates and provides information that strengthens the cases against them. Or those arrests could take more time if investigators want to use Gettys' cooperation to gather additional evidence before moving against the others. Either way, charges against Daniel and Malaya are coming. The evidence against them has been building for months, and prosecutors are preparing cases that they believe will result in convictions. When those arrests happen, when Daniel and Malaya are charged, this case will enter a new phase. The focus will shift from the investigation to the prosecution, from gathering evidence to presenting it in court, and the Sullivan family will face the difficult process of sitting through trials, of hearing detailed testimony about what happened to their children, of reliving the trauma over and over again as lawyers argue about evidence and witnesses testify. It will be painful, it will be difficult, but it's also the path toward justice. For those of you who have been following this case from the beginning, who have been waiting for answers, who have been demanding accountability, the message is this: progress is happening. It's happening slowly. It's happening methodically, but it's happening. The investigation never stopped. Investigators never gave up. They've been working behind the scenes, building cases, gathering evidence, preparing for this moment. Each year, and now we're here. Arrests are coming. Charges are being filed. The justice system is engaging. Will it bring Lily and Jack back? No, nothing can do that. Will it ease the pain of their family? Probably not. No amount of justice can fill the hole left by the loss of a child, but it will provide answers. It will establish the truth, and it will ensure that the people responsible for what happened face consequences. That matters. It matters to the family, it matters to the community, and it should matter to all of us. Because when crimes against children go unpunished, when people who harm the most vulnerable among us face no consequences, it sends a message that those lives don't matter, that justice is selective, that some people can get away with anything. We can't let that happen. So we watch, we follow these cases, we demand accountability, we support the families, and we trust that the justice system, imperfect as it is, will ultimately do what's right. That's why I cover these cases. That's why channels like this exist. That's why you're here watching, because Lily and Jack Sullivan mattered. Their lives had value, and what happened to them deserves justice. This has been a detailed look at the breaking developments in the Lily and Jack Sullivan case, focusing on the imminent arrest of Darren Gettys and what it means for the broader investigation. As this case continues to develop, I'll be here providing updates, analysis, and context. If you want to stay informed about this case and other untold cold cases that deserve attention, you need to subscribe to this channel. Click that subscribe button right now. Turn on notifications so you're alerted the moment I post a new video with breaking information. And please engage with this content. Leave a comment below sharing your thoughts on this development. Do you think Gettys will cooperate? What do you think happens next? I read every single comment and I want to hear from you. Hit that like button if you found this coverage valuable. Share this video with people who care about justice and accountability. The more people who know about these cases, the more pressure there is for answers. Follow me on social media for updates between videos. I post breaking news there as it happens, sometimes before I have time to create a full video. And consider supporting the channel if you're able. This kind of in-depth coverage takes time and resources. Your support allows me to keep doing this work, keep covering these cases, keep demanding justice for victims who deserve to be remembered. Thank you for being part of this community. Thank you for caring about these cases. Thank you for demanding answers and accountability. Together, we're making sure that Lily and Jack Sullivan and victims like them are not forgotten. I'll see you in the next one. This is the Untold Cold Case.